The fourth important landmark judgment in relating to intellectual property right in particularly the Indian patent law and patent right, and here we would like to discuss that judgment delivered in 2013 that was relating to Novartis vs. Union of India, where the very issue raised regarding the imaginable missolit and the patents and the intellectual property right of Gilmore and the very facts relating to patent application for Glivec, the enhancement of efficacy as provided under Section 3, Subsection D of the Indian Patent Act 1970. So we would make a critical analysis about the very judgment delivered by the Chennai Patent Office and its relation with the trade-related intellectual property rights and the very judgment and the legal implications and the conclusion. So, as relating to the very introduction, the important judgment, the Indian patent law, and that had a profound impact on the interpretation and application of the patentability of that particular patent right in India. And as this very legal battle that was centered in 2013 relating to the application for the cancer drug Glivec, which is otherwise known as imatinib left, claiming that it was more effective in fighting leukemia and has far-reaching implications for the pharmaceutical industry and access to affordable medicines. So, this case is essential relating to the very significance of intellectual property right and patents. As intellectual property grants exclusive right to inventors and creators, protecting their innovation and encouraging further innovation. Patents, a subset of intellectual property right, provide statutory rights to inventors, granting them the ability to exclude others from making, using, or selling their inventions for a limited period. So, in relation to that, we would discuss the very patent application for Gilmore, and that is relating to the cancer drug. So, here the plaintiff Novartis, the leading multinational pharmaceutical company, filed a patent application for the beta crystalline form of the immaterial mesylate, the active ingredient in the cancer drug Glivec. Novartis, the plaintiff, claimed that this new form of the drug exhibited enhanced therapeutic efficacy compared to the known substance. As imatinib, this application set the stage for a critical examination of patentability criteria and the concept of evergreening as per Section 3 D of the Indian Patent Act 1970, the very provision specifically designed to prevent the very practice of evergreening. It states that inventions involving mere discovery of a new form of known substances or a new proportion known substance or the mere use of a machine or apparatus or knowledge unless they result in enhancement in efficacy are not considered as patentable. The provision emphasizes the necessity for inventors, inventions to demonstrate a genuine enforcement in efficacy to be eligible for patent protection. Novartis challenged the validity of Section 3, subsection D, arguing that it violated the agreement on trade-related aspects of intellectual property rights or TRIPS and the fundamental rights to equality under the Indian Constitution. So the present case was transferred to the Intellectual Property Appellate Board for consideration and a final decision. But the Intellectual Property Appellate Board also rejected the application upholding the Patent Office's decision. And the very rejection, the patent application for Glivec faced challenges and rejections. As the Chennai Indian Patent Office rejected Novartis application citing lack of novelty and non-obviousness. Moreover, it invoked Section 3, subsection D of the Indian Patent Act 1970, which states that inventions involving the mere discovery of a new form of a known substance, unless they result in a significant enhancement in efficacy, are not considered patentable. This provision aims to prevent the practice of evergreening, where pharmaceutical companies make minor modifications to extend patent protection and maintain monopolies. So, in that connection, we will discuss the very proceedings in the Supreme Court that after the Intellectual Property Appellate Board has upheld the rejection of the Novartis application as it was based on Section 3, subsection D. The case finally arrived at the Supreme Court of India. And the apex court, the Supreme Court, in its landmark judgment in 2013 ruled against the plaintiff. That was the Novartis upholding the validity of Section 3, subsection D of the Indian Patent Act 1970. The court emphasized that for pharmaceutical invention, efficacy referred as specifically to therapeutic efficacy. It held that the beta crystalline form of imitative mislet did not demonstrate a significant enhancement in therapeutic efficacy over the known substance and therefore was not eligible for patent protection. So the very judgment In this important landmark case, Novartis vs. Union of India in 2013 has significant impact regarding prevention of evergreening, and in particularly it strikes a balance in between intellectual property rights and safeguarding public health interests by setting a high bar for patentability and emphasizing the very importance of genuine therapeutic enhancement. The judgment delivered in 2013 curtails unwarranted patent monopolies and foster competition in the pharmaceutical sector. As in this regard, we would like to discuss the very legacy of the judgment. So, the very judgment serves as a significant milestone in Indian patent law, highlighting the balance between intellectual property rights and public health consideration. It reaffirmed India's commitment to promoting access to affordable medicines and preventing the undue extension of patent monopolies through evergreening practices. So, finally, we would like to conclude our lecture on this very fourth important landmark judgment that we have selected out of our research relating to intellectual property right landmark judgments, and in this particular case Novartis vs. Union of India, which was decided in 2013. Now we would like to conclude about the very judgment and the very discussion. The Novartis vs. Union of India judgment as delivered in 2013, which remained as one of the key judgments in Indian patent laws, in particularly the Indian Patent Act of 1970, which was clearly demonstrating the importance of actual medicinal efficacy as provided under Section 3, Clause D of the Indian Patent Act for patentability, as it had profound consequences for the pharmaceutical sector. Finding a balance between intellectual property rights and public health concerns. This judgment of 2013 was continuing to impact the current problems, those arises out of the Patent Act of India of 1970, the Indian Patent Act 1970. So, it influenced the subsequent judgments delivered by different courts in India, and it was ensuring access to affordable medication for millions of people in India. As for this landmark judgment delivered in 2013 in this landmark case Novartis vs. Union of India relating to Glivec